Did you know what insolvency is? Have you ever come across the term bankruptcy while reading newspapers? Can you tell what is the difference between the two? Did you ever wonder why IBC is a code and not an act? If yes, then this tutorial is for you. If you stay with us for next 10 minutes, you will get an answer to all your questions. Not only that, you will get to know the background of IBC and how it evolved. Let's say we have a company A which used to procure raw materials from another company B. As per mutual agreement, B was supposed to receive full payment within 30 days of delivery. Everything was going fine until there was a labor issue in company A, followed by a lockout for which A failed on its payment commitments and B didn't receive its payment even after 30 days. Insolvency is a state where a person or firm is unable to pay back the debts owed when it fell due. In this case, A is the company which became insolvent. B tried its best, but when talks failed, it approached the appropriate court and sought their intervention to recover the amount. If the creditor approaches the appropriate court or adjudicating authority to recover its dues from the debtor, and the adjudicating authority decides the insolvency of the debtor, then the status of the debtor becomes bankrupt. Bankruptcy refers to a legal status imposed by the courts which highlights their obligation towards the creditors they have taken loans from and their inability to repay the same. Adjudicating authority means any authority who is competent to pass orders. In case of IBC, it's NCLT. NCLT is a special court which handles cases related to IBC. Now you may ask why IBC is called a code and not an act. The act in Indian context is a decision passed into law by the Parliament, and code is a collection of acts already passed into law. Now, if IBC is a code which is a collection of acts, what are the acts? These are the statutes which were impacted by the code. You may pause the video to take a look before we move forward to get a bird's eye view for a few of them. In order to understand IBC and how it evolved, it is important to take a look into the background and previous dispensation methods of NPA till the IBC was introduced in 2016. Firstly, the Sikh Industrial Companies Act of 1985, popularly known as Sikha. In the 80s, India witnessed an atmosphere of rampant industrial sickness. Therefore, for the first time, Sikha was introduced. Banks and FIs were facing the major crisis as they were the backbone for any economy, and this widespread industrial sickness was increasing non-performing assets held by banks and financial institutions. So this act was enacted to make provisions for the timely detection of Sikh companies owning industrial undertakings. The provisions of Sikha established two bodies: the Board for Industrial and Financial Reconstruction and the Appellate Authority for Industrial and Financial Reconstruction. BIFR was the major step for intervening at an early stage, detecting, preventing, and taking decisive remedial measures with respect to Sikh but potentially viable companies. The main function of appellate authority was to determine the sickness of such industrial companies and to prescribe measures either for the revival of potentially viable units or the closure of unviable companies. SICA was later repealed by the Sikh Industrial Companies Repeal Act 2003, which diluted certain provisions of SICA and filled the gaps and loopholes. One of the major changes to the new law was that, apart from tackling sickness of the companies, it also focused on bringing down its increasing frequency by ensuring that companies did not resort to a sickness declaration merely to escape legal obligations and gain access to concessions from financial institutions. All these things are now replaced by the IBC 2016. The repeal of SICA came into full effect from December 1st, 2016, and the AAIFR and BIFR stands dissolved. SICA was fully repealed because some of its provisions overlapped with the Companies Act 2013. The Companies Act included the creation of National Company Law Tribunal and National Company Law Appellate Tribunal. In 1993, Recovery of Debt Dues to Bank and Financial Institution Act was introduced mainly to deal with the rising NPA. This act was applicable only when the amount of debt due to any bank or financial institution or to a consortium of banks or financial institutions was more than 20 lakhs. The central government had powers to alter the amount. In 2001, corporate debt restructuring was introduced by RBI to restructure the debts of the corporates having potential to turn around. Thereafter, in 2003, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act was introduced. This new legislation became a game changer as it empowered banks and FIs to gain possession of the securities and to sell them without any intervention of the court. Next major dispensation method came in 2014. The revitalization distressed asset in the economy and flexible structuring of long-term loan was introduced. In 2015, strategic debt restructuring was introduced by RBI to deal with the rising NPA crisis and to restructure the eligible corporate accounts. Further, in 2016, Scheme for Sustainable Structuring of Stressed Assets was introduced by RBI with similar motives. All these previous dispensation methods and acts had their own limitations. Multiple legislation and interpretation which made the process time consuming, resulting in deterioration of the value of the assets. And we know longer resolution keep away major investment in revival of the business. There were no specific time-bound resolution met out of these dispensation methods, which lead to deterioration of assets and reduction in the chances of survival. The lack of efficiency to tackle the rising NPA and negligible say in recovery processes by banks and FI paved the way for collateral-based lending, no focus on cash generation, health of the business, high exposure to few large corporate houses, asset-heavy industries, dependence on real estate-based collateral which were actually not so easily disposable. All these were against the government motive ease of doing business. The ease of doing business required a proper exit mechanism for the investors, which was not available. The key theme of the code is to consolidate all laws relating to insolvency of companies, limited liability entities, unlimited liability partnerships, and individuals, presently governed by multiple laws into single legislation. As we can understand, all the dispensation methods needed some more comprehensive time-bound resolution to the corporate NPAs as well as revival mechanisms wherever the chances are there. The code was passed by Parliament in May 2016 and became effective in December 2016. The IBC has 255 sections and 11 schedules and aims to protect the interest of all stakeholders and make the process of doing business less cumbersome.